Welcome to Channel 17, the Town of Colonie Government Channel.
All right, everyone, thanks for coming. I think a lot of people are interested in the Supreme Court, so we have a nice crowd. A couple years ago, when Jeffrey Toobin wrote his book, The Nine, Inside the Secret World of the Supreme Court, I tried to get a judge to come, and they seem very reluctant. Oh, we can't comment on, but Peter is not shy about doing that, so I'm glad he wanted to come and talk about this book. Peter's been the town justice for 10 years. He's worked for the town for over 20. And the book is called Packing the Court by James MacGregor Burns, and the subtitle is very interesting too. The subtitle is The Rise of Judicial Power and the Coming Crisis of the Supreme Court. So here's Colonie Town Justice Peter Crummey to tell us about it.
Thank you very much, Joe, and thank you very much for coming out today, despite the challenging weather that we're having this afternoon. But obviously, we're in good form here at the Colonie Town Library, and all of us recognize what a significant venue the Colonie Town Library is throughout not only our own town, but throughout the capital region. And of course, I remember, and as often so many of us do, the development of the Colonie Town Library over the past 50 years. And I certainly recall my summer reading visits with my mom, who's here today, back in the early 60s to the then town library, which was housed behind the old Shaker Road, Loudonville Fire Department. So we're here today now, and so very happy to have such a venue here. It's really a source of community pride for all of us. Packing the Court, the Rise of Judicial Power and the Coming Crisis of the Supreme Court by James MacGregor Burns incorporates by its title the basic presumption that there is a coming crisis in the Supreme Court. James MacGregor Burns is no stranger to authoring a variety of compelling books focused on various aspects of United States government. Burns has authored no less than 14 books on subjects and has won a Pulitzer Prize and the National Book Award for penning Roosevelt, Soldier of Freedom. Burns is the Woodrow Wilson Professor of Government Emeritus at Williams College and Distinguished Leadership Scholar at the James MacGregor Burns Academy of Leadership at the University of Maryland. In Packing the Court, released in 2009, Burns takes us back in time chronologically, developing the establishment and the evolution of the Supreme Court of our United States of America. Burns lists the specific duties of the court as enumerated in our Constitution and reveals the content of early discussions about the character of the court by our framers of the Constitution. Burns points out that the Constitution provides for certain direct powers for the court, such as having jurisdiction over disputes between states or between an individual as against a state, or jurisdiction over treaties engaged by the United States of America. Burns then asks the compelling question underlying his book, which is, where did the Supreme Court get the power to strike down legislative and executive prerogatives and initiatives as unconstitutional? Where did the power of judicial review come from? Burns says there is no provision in our Constitution for establishing the power of judicial review. In fact, Burns strenuously points out that the framers of our Constitution were so intent on creating a government for the people, by the people, with legislative representatives in its democratic republic, answering to voters at the ballot box every 2 to 4 years, that the framers would never have created a court so powerful and so unaccountable to the populace. How did the court then get this power? And that is the first issue that Burns embarks on before he challenges that power and urges action. Many constitutional scholars may be with us today and may know so much more than this reviewer about the infamous Supreme Court decision of 1803, wherein the Supreme Court gathered for itself the power of judicial review over legislative and executive acts. The Supreme Court decision of Marbury versus Madison in 1803 is often cited as the seminal case creating judicial review. At that time, the Supreme Court was led by Chief Justice John Marshall, a well-known Federalist who supported the notion of a strong federal government as opposed to merely having a nation of loosely aligned states. Marshall was brilliant in utilizing the fact pattern presented in this case to establish his power, which he then exercised for more than 30 years, keeping his position as Chief Justice of the Supreme Court. The case is fabulous. It involves a gentleman by the name of William Marbury, who, when President Adams, on his last day of office, President Adams decided to appoint William Marbury as the first and brand new Justice of the Peace of the newly created District of Columbia, Washington, D.C. So John Adams, busy attending to signing documents, appointing people he thought would best serve in these capacities, designated that William Marbury would get this job. At the time, President Adams's Secretary of State was John Marshall, who was also serving as Chief Justice of the Supreme Court. That's great. 2 jobs at one time, in the early 1800s. The last day the president's in office, he says, make sure you deliver this letter to Marbury so he can have his job. A lot of things going on the last day. Even John Marshall forgot to deliver the document to Marbury. Jefferson comes in the next day, sees that it wasn't delivered, says, I'm not going to give him that job. Marbury's a friend of Adams. And Adams and Jefferson weren't friends. And there was no reason why Jefferson was going to appoint an Adams appointment to serve as Justice of the Peace of Washington, D.C. Well, Marbury didn't take that lying down and decided to go into the court system to see whether he could get relief there so he could have his job as Justice of the Peace. Finally, winding its way to the Supreme Court in 1803, who's the Chief Justice? John Marshall. You'd think today that maybe the Chief Justice would say, I don't think I can sit on this case. But that's not what happened then. Marshall saw this as a fabulous opportunity to make some law. Marshall didn't like Jefferson either. These people were battling all the time. The battle of wits between these very intelligent people who actually created the genesis of our great nation. And I believe it's the tension between these great wits and great talents that actually have brought us to what we have today. But nonetheless, tension existed. So, what does John Marshall do as Chief Justice when this case arrives? Well, he certainly doesn't excuse himself. He takes the opportunity to first decide, in order to tweak President Jefferson, you know what? William Marbury should have that job. He should have that job, Mr. President. And number 2, Marbury certainly had the right to come to the courts to get that job. And this is where it gets really good. Marshall decides, rather than to then conclude, okay, give Marbury this job, Justice of the Peace job, Washington, D.C., he didn't do that. He saw a better opportunity for himself and for the nation. Remember, Marshall's a Federalist. He believes in strong federal government. I think he's succeeded in our current climate. But nonetheless, back then there was much debate about whether we should have such a form of government, but we do today. So what does Marshall do? He says, you know what? Even though Marbury should have this job, and even though he was allowed to come to the courts to get relief, I can't give it to him. I can't give little Mr. Marbury this job because his attorney was relying on the Judiciary Act of 1789 in order to provide the basis for why Mr. Marbury should have this job. And Chief Justice Marshall writes that actually the Judiciary Act of 1789, or parts thereof, are unconstitutional. Therefore, that act, the Judiciary Act of 1789, I'm ruling is unconstitutional. Therefore, I can't give Marbury his job. Well, short-term gain for Jefferson, right? Because Jefferson says, see, didn't get his job. Well, actually, Marshall was far more clever. Because what he was able to do without objection was to say, we have the power to decide whether laws and acts of Congress are unconstitutional. And he took that power then, while at the same time giving Jefferson a short-term win, and then took that power. And that's the power which is the subject of this book today. Marshall was brilliant. You know, Jefferson underestimated the entire case. Why is it called Marbury versus Madison? We all know that William Marbury was the gentleman who wanted that job as Washington, D.C. Justice of the Peace. Madison, it's not President Madison yet. James Madison was Secretary of State for Jefferson. And the lawsuit was attempting to compel Secretary of State Madison to hand over the appointment document that Adams signed on the last day of office. Madison took it so lightly and Jefferson took it so lightly, they never even sent anyone into the Supreme Court to argue their side of the case. They thought it was a political stunt, and we don't even have to recognize it. Don't recognize it, you'll give it life if you go down there and fight about it. Left unanswered, Marshall drove that train right through and then took the most important power of our Supreme Court today. Since that time, Burns argues that the court has now become a most powerful branch of government, wholly unaccountable to the citizens. Since the beginning of our nation, presidents have wrestled with the court until which time they get their own appointments to the bench. Many are familiar with the phrase, packing the court, arising during the 1930s, when President Roosevelt was introducing a variety of New Deal legislation on the Republican appointment control of the Supreme Court at that time, was not very much enamored with Roosevelt's proposals, New Deal proposals, and routinely struck down New Deal proposals by Roosevelt time and time again, struck them down as unconstitutional, using their power of judicial review and striking them down. Roosevelt set forth the notion that I would like to increase the size of the Supreme Court. It's 9 members in the 1930s. I propose we make it 18, knowing he'd get all 9 new appointments, he would take control. That's packing the court. He didn't work as closely with his Congress as he should have, because the chairman of the Judiciary Committee at that time was upset one day with Roosevelt and said, I'm not taking that up, and Roosevelt never got to increase the size of the court. However, Father Time was good to President Roosevelt. After his compelling 3rd election, re-election to the presidency on his 3rd term, the Supreme Court wisely recognized his power and his credibility with the citizens in the United States during the 30s, that they certainly were kinder to him at that point, recognizing that they don't need to continue to confront him. Everybody draws a certain line a Mason-Dixon line where they realize they shouldn't continue to cross if they want to make sure they can maintain their own credibility and not have to confront the challenge that Burns brings to our attention, which is they don't have this power anyway, so what are we letting them do it for? At that point, the Supreme Court in the late 30s began to temper their decisions as against Roosevelt. Roosevelt's not the first president, by the way, to attempt to alter the size of the court. It's currently 9. In fact, the size of the court originally was 6. In 1801, it was reduced to 5 by Congress. Why? There was a vacancy coming up. Jefferson was president. Congress didn't want Jefferson to get the appointment to fill the vacancy. So they just said, guess what? There's only 5 now. Took his appointment away from him. So Jefferson didn't get any appointment at that time. By 1807, though, Congress decided to increase the size of the court to 7, and then in the 1860s to 9. And that's where it is today. Presidents and presidential candidates routinely attack the court, from President Lincoln to President Nixon. It's fashionable, typically. How many times have we heard on the political stump, judges need to judge, not legislate? Until which time, of course, their own appointments are there. Then it's different. To underscore the power of the court and its obvious bent, depending on who sits on the court, Burns spends a significant amount of time on the court's Dred Scott decision of the late 1850s, which Burns believes merely highlighted the great division on slavery in our country at that time, and the decision itself was very much a catalyst for civil war. In this court, Burns points out that many of the judges were slave owners themselves, and the legal battles between Federalists and those who supported states' rights continued. Burns expresses his obvious displeasure with the court's ultimate ruling, which essentially continued to allow slavery. You know Burns doesn't like it. The chapter is called the Dred decision. Well, Dred Scott is the name of the slave born in Virginia at some point, and of course birth records aren't that readily available, certainly not to our author here today. But there came a time when Dred Scott was brought by his owner to a free state and freed by his owner. At that point, there were free states and those states that were not free for slaves. The slave returned back to his former state in the South, though, into Missouri, I believe. And at that point, was considered a slave again. His position was, and the family that freed him, who helped bring this action into the courts, is that once freed, always freed. Dred Scott decision now may look like a black eye to all of us today. We recognize that even the Supreme Court, in making decisions, often subsequently makes other decisions to right a wrong. Dred Scott decision was very upsetting to Burns at the time, and as a result, the famous quote about Dred Scott is, and of course the court ruled, and many of the justices at the time were slave owners, that actually slaves weren't citizens, therefore the United States Constitution and its protections don't apply. And if the state chooses not to recognize them as citizens, as Missouri hadn't, as no state had at that time, then therefore they have no protections at all. And they can't be citizens, so there are no protections. Actually, all the court was doing, on the one hand, was supporting states' rights, that because there are many states that didn't want the federal government regulating slavery. Not a federal issue, it's a state issue. And so the Supreme Court decided in the late 1850s, on the eve of the Civil War, that it's a state issue. And actually, the Constitution doesn't apply to slaves. Famous quote, of course, along the lines that Dred Scott went into the Supreme Court a free man. and left a slave. Burns points out that some presidents serve without having any appointments to the Supreme Court at all. I don't think Jimmy Carter had one appointment to the Supreme Court. Other presidents have numerous appointments to the Supreme Court, and some presidents end up controlling the court with their appointments for 30 to 40 years, long outliving the president that appointed them in the first place. President Taft being one of them, who served as our president of the United States, making a number of appointments himself as president. And then, after serving as president, he was appointed Chief Justice of the Supreme Court, thereby controlling for himself the activity of the court for decades. Burns spends 246 pages presenting an able history of major players in this court's power evolution. Burns concludes that actually the Supreme Court has absolutely no right to the power of judicial review, which was created self-servingly by Chief Justice Marshall in 1803 in that famous case, Marbury versus Madison. Therefore, Burns urges that our current president ignore and refuse to obey any decision of the court based on the court's alleged power of judicial review. A 200-year tradition of United States governance to be tossed aside. Those who oppose Burns's call for executive and congressional revolution against the court's judicial review would argue that the court has a better view of issues brought before it than other branches of government. Some argue that legislators act typically for the moment, seeking immediate popular support, as they typically run for office every 2 to 4 years. The Supreme Court is insulated from that environment. Remember, appointments to the federal bench are lifetime. Supreme Court judges can sit for as many as 30 years. I think the longest is approximately 36 years as a Supreme Court justice, spanning a long period of time. Usually, by the time the Supreme Court takes an issue, the issue has been vetted in lower courts, by the media, by national, state, and local bar associations. Courts may have a better opportunity to consider the long-term and short-term impacts of an issue. Remember, too, we should recognize for those who would oppose Burns's call for revolution against the Supreme Court's power, that we probably wouldn't have the nation today that we do without that strong Supreme Court. Actually, those decisions, right or wrong, have unified the land under one law many times. And without that federalist notion promoted by John Marshall and those who have succeeded him in a variety of governmental capacities, we may not have the strong nation that we have today. On the other hand, those who support Burns's call for executive and congressional revolt would certainly agree with Burns that the court is insulated from accountability, never elected by the people, and routinely long outliving their appointing president, some serving, as I said, 30 years or more on the bench. The framers of the Constitution, in developing a government for the people, by the people, Burns argues, would have never created a Supreme Court so detached from the citizens and so powerful, without accountability to the citizens, Burns argues. It would be unusual that everybody in this room agree with every decision of the Supreme Court. In fact, the Supreme Court, in its evolution, has often maneuvered itself around its prior decisions in order to arrive at an intended result. Nonetheless, we all believe that the Constitution is our framework of democracy, and in order for it to remain a living and breathing source of democracy, it does require, ultimately, that a court exists to ensure its viability. And I'd like to thank James MacGregor Burns for authoring this fabulous book, and I want to thank you all for coming as well. And thank you. Joe? This isn't the one I gave him either.
Does he think his idea of going against could work?
He's calling on our current president. Now, and you know that his last chapter is Ending Judicial Supremacy. That's the last chapter in the book. Very powerful. And he's urging the president, our current president, the next time a decision is rendered by the Supreme Court ruling legislation unconstitutional, that the president ignore it. Ignore it. Burns suggests, he points out, that the president took an oath to faithfully discharge the duties of the office, including supporting the Constitution of the United States. That's part of the oath. So why don't we presume that that's exactly what the president would do? And he's urging, like Andrew Jackson thought of in the 1830s, President Jackson, let's see if the court can enforce it. Jackson went away. Courts sometimes have a way of giving certain things to presidents in order to retain their own viability. I'm sure there's some sense of wanting to continue your own business as well, and certainly trading over the years is no doubt part of the Washington scene. Nonetheless, though, I don't know whether he believes that our current president would actually wholly disregard a decision by the Supreme Court based on its judicial review. Burns recognizes the Supreme Court does have some duties it's supposed to take care of, and those are the ones specifically laid out in the Constitution, but does not enjoy this power. And although it's been exercising it for 200 years, created by that wizard John Marshall, in 1803, Burns says it doesn't exist, and why don't we pick a fight now? I don't know what the current president would do about that. Other presidents have contemplated, but even contemplated that action. Even Roosevelt didn't contemplate that. He tried other ways to get control of that court, including doubling the size of it, but never thought about ignoring it. James MacGregor Burns calls us to action and asks us to do just that. Any other questions? Yes?
Why are they able to serve a full lifetime term? Is there something written if that's what they do?
That's correct. I believe that the federal judges enjoy lifetime appointment through federal law and the Constitution. It's lifetime, as opposed to a colony town justice, which is 4 years. And other justices, including our state Supreme Court justices, are 14. It's only the federal system that I can readily acknowledge have this lifetime appointment. And in fact, if you, in the back of this book, there's some other interesting information, gratuitous information, but certainly he lists all of those who have served as a Supreme Court justice and the reason for their leaving. There are many who have retired before passing, but I would argue that there's certainly as many or more that actually passed away in office. It's a lifetime appointment. And that's something that our framers designed long ago, and I think they did it with the notion that they would be unfettered by politics. If they had a lifetime appointment, they wouldn't have to worry about political parties warring and the rest of it, because they were immune from politics now because they had a lifetime job. And they never would have to go back to Congress and ask them, can I please be appointed? Yes?
But the lifetime span at that time was much shorter.
I agree. But I think they did it to try to insulate them, insulate federal judges. Now, federal judges aren't just Supreme Court judges. There's a whole cadre of federal judges, including federal district court judges, that also enjoy this lifetime appointment. So And again, you've recognized that maybe the average age of the judge has actually increased over the last 200 years as well, which is another issue raised by Mr. Burns about the lifetime appointment. I don't know whether you'd ever get Congress to change that notion, though. Yes, and then we'll go here. Yes, sir. Did you have a question? No?
Yes.
Yes, go ahead.
Under what general conditions does the Supreme Court accept or reject cases?
That's a great question. And you know what's very interesting about their court? They pick what they want. You have to ask them, litigants have to ask them for permission. You just can't walk into the Supreme Court and say, hey, you're next. Last judge I didn't like, now you. Oh, no. Even our Court of Appeals, which is the highest court in our state of New York, there are certain cases it must take. Supreme Court of the United States, you have to ask permission. They pick what they want. In fact, the current data suggests that as many as 10,000 applications a year are made to the Supreme Court, will you hear my case? They may elect to take 100 or so a year, maybe 200. All right. They pick and choose. Meaning that for most people, the last stop in the federal court system is the Federal Circuit Court of Appeals. That's the last stop. The Supreme Court decides who gets to it. So it can take what it wants, when it wants, or choose to just leave the Federal Circuit Court decision the law of the land at the time. So they decide. Yes, sir.
You know, that brought up like two questions now. One, who among the Supreme Court justices decides what cases they're going to see? Is that a vote internally? You know, you say that they can pick and choose. Who's the final decision maker on that?
Well, I would say that typically it's that issue is conferenced as a group. The 9 spend a lot of time together when they're sitting and reacting to cases that have been proposed for their review. I would say that collectively they make that decision. I don't think there's any question after reviewing this book that the Chief Justice wields the most singular power. That seems to make sense to all of us. Well, you're the Chief Judge, so you certainly control the docket, calendaring, and influence. But there are many times when the Chief Justice is, on the course of the over 200 years, was on the short end of the majority. Remember, only 5 votes needed. So there are times when the Chief Justice has been on the short end of the vote. But I would say that the single most important person for directing traffic is the Chief Justice, but they all collectively make a decision whether they want to take that case or not. And then the Chief Justice will appoint a certain judge to actually be the point person on it to create a decision. And then it's brought back to the 9 and they review it. Some may choose to sign on to the decision. Some may choose to sign on in part, disagree in part, and others may dissent. Some of the famous legal words ever printed are in dissents found in the Supreme Court. You had another question?
Yeah, just one more. Now, you're up for re-election in 2 years.
That's correct.
Okay. Now, why do we have to re-elect the town justices when we had no say over the Court of Appeals or some of the other courts? And I personally don't think the electorate should vote for a judge because I don't know enough about qualifications.
Currently, our New York State Constitution has put in place this town and village justice with a 4-year term. So the framers of our own New York State Constitution have decided that there should be a town or village justice, and they should have a 4-year term. So it's embedded in our own state constitution now, and that it's subject to election, just like a town board member or receiver of taxes or a town supervisor in that way. And as in New York State, as you pointed out, most of our judges have to go to the ballot box. Most of them do. In fact, our Court of Appeals judges did as well. And that's the highest court in the state of New York. The Supreme Court of the United States is the highest court in the land. In New York, though, the highest court in New York in our state system is called the Court of Appeals. They were subject to statewide elections up until the mid-'70s, and subsequent to a constitutional convention held here, the change was made so that they would then become appointed, and those judges now, those Court of Appeals judges, are appointed. But they also stood for elections statewide up until the mid-'70s.
So you're not immune to conflict of interest?
I don't think a judge ever could be. I don't think you could, that, and if you see one, you're recognized.
You have to excuse yourself, right?
Sure. And at the same time, remember, and of course the chief judge in our judicial district years ago pointed out, you can't allow forum shopping either. There are times when litigants might want to suggest, that judge won't be fair, won't be fair. Well, the record will decide in the end, and that's why we have appellate courts. But the idea of allowing forum shopping is certainly to be frowned upon. And a mere bare allegation that won't be fair certainly can't be condoned in order for a proper running judiciary. All litigants coming into court, they don't think they're going to get the decision they want, so they just say it's not fair. That's why we have appellate courts. Okay. I suppose a classic example of a conflict, if your own child was arrested and came before you as the judge, I guess you probably have to say, excuse, and put it right on the record. Put it right on the record that I can't preside over that matter, or some kind of civil matter involving a family member or a former client. Stand up and say, you know what? No, I represented this person 10 years ago. Tell them right away. I had a case in the city of Albany. I was asked by the city of Albany through the Office of Court Administration to come down and actually serve the city for about 40 different times. They were needing assistance, and I said that I would help them. And I inherited a trial. And one of the parties was the owner of a parking garage in downtown Albany. One of the parties happened to be one of them. They owned the parking garage that I parked my car in. What did I do right away? So you know what? I just want to tell counsel right away. I parked my car behind 90 State Street in a parking garage that I believe is owned by this company. I want everybody to know that. Does anybody have a problem with it? Both attorneys said, no, Judge, we don't have any problem with that. But I looked that deep into it. As if parking your car actually would be a conflict, but why not just say it up front? Tell everybody. Better to disclose. Tell them, I think I parked my car in there, and let them know up front. Because you don't want the integrity of your proceeding undermined later for some reason like that. Any other questions? Yes?
I don't understand how you can oppose judicial review. For example, the Brown Board of Education, and suppose someone in the South said, well, I don't believe in judicial review, so I'm not, well, that's then a crime. I mean, and even if the president were to do it, he said, oh, you're breaking the law. How can you do it without not being accused of a criminal act in a case like that?
Well, Burns, of course, is advocating to remove the power from the court that it took itself for judicial review. I'm not here advocating that, though. And in fact, in my closing comments, I think that in order to maintain our Constitution as a viable, working, living, breathing document, in order to continue to guide us, we all recognize that times change. And if that Constitution will continue to work with us as a framework for rights and responsibilities of government and people, it will demand that a court ultimately have the opportunity to adjudicate those issues. Burns, though, believes otherwise, and that it shouldn't exist, and we should just trust the President and Congress to act according to the Constitution and not take in any time the court renders a decision, according to Burns, using its power of judicial review that it took 200 years ago, ignore it. I'm not quite sure why he thinks that would be the best way to go. But I think Burns, to some degree, is displeased that John Marshall was so artful in taking the power 200 years ago. And obviously, Mr. Burns is very wise in his own works over the years, too, having written no less than 14 books. I believe up to the last chapter, though, his presentation of the history and the evolution of the power and the politics of the Supreme Court is well worth the reading. And thank you very much for coming out here today. Thank you.